I'm so not used to. Good afternoon, and thank you for joining us to the virtual listening session that we're going to be doing for the understanding of the new Title IX regulations. Next. Today's dialogue really goes into looking at the regulations 34 CR or CFR 106. On the call today and on this virtual session, you have myself. I'm Vicki Kalicki. I'm the Director of Title IX and Compliance and also the Title IX Coordinator. Katrina Notke, who is the Assistant Director, Title IX and Compliance, and Michelle McDivitt, the Title IX Investigator. Lindsay Tuttle, the Sexual Misconduct Prevention Education Coordinator, is also part of the Title IX team. Thank you. It's really important as we're doing this and having this as a mutual listening session that we really pay attention to the community of care statement. As a participant in this listening session, we ask you to be respectful of your peers' thoughts and opinions. The intent of this listening session is not to be confrontational or argumentative with one another, but to be a space where UToledo community members can be in their authentic selves and share their thoughts and feelings with a civil manner. Again, due to the nature and sensitivity of the listening session, it is very important to practice self-care. Some of the program objectives today is really to educate the University of Toledo community on the new Title IX regulations, which will go into effect on August 14, 2020. It's also to provide opportunity for the University of Toledo community to ask questions about the changes to the Title IX regulations, and also provide opportunity for the University of Toledo community to access available resources. Individuals that are on the listening session and part of the panelists today are individuals from the Office of Human Resources, the Office of Faculty Labor Relations and Academic Inclusion, the Title IX Office, the Office of Student Conduct and Community Standards, and Greek Life. As we look into the program overview and some of the major changes to the Title IX regulations, I want to first stop and thank Dr. Cockrell, the Vice President for Student Affairs and Vice Provost, for his support and continued effort and work in the Title IX area, along with President Gaber and Provost Dr. Bjorkman. Some of the major provisions that we have seen coming out of the regulations and the information that we are looking at and reviewing right now for our policy and procedures specifically have to do with all the key bulleted points here. I would tell you basically that this huge undertaking of looking at what these new regulations is not something that we take lightly or that we just started doing. On May 6th, we received what the new regulations were, but prior to that, the University of Toledo, we had meetings and been looking at our policies that we review every single year to make sure that we are doing the best practices. But what's really important is that this final document that was released was 2,033 pages long. These new regulations start specifically on page 2008. One of the big components of this, particularly that we have been wanting to make sure that the community understands, is that these are now regulations, things that we have to make sure as an institution that we put into our policies and procedures. And then some of the things that I'll be talking about today is just a small portion of everything that we'll be working on moving forward. So let's start by talking about notice to the school. What is actual knowledge? So institutional obligations are triggered once the institution has knowledge of sexual harassment. The final regulations state that once a school has an actual knowledge of sexual harassment or allegations of sexual harassment, the school has to respond and take action. In all schools, colleges, and universities, and elementary and secondary schools, the school must respond whenever the school's Title IX coordinator has notice. Reports can be made to a school's Title IX coordinator by many ways. It can be by mail, by phone, by email, online reporting systems, and it can be done at any time. It can be a day or night, and also in person if the person wants to come in. It can be verbal or it can be written, but these are ways in which we have actual notice. Also, in all schools, the schools must also respond whenever a school official with authority to institute corrective measures has notice of sexual harassment. Schools are responsible for preventing sexual harassment in locations, events, or circumstances over which the school exercised substantial control over both the respondent and the context in which the sexual harassment occurred. So basically what we're saying is schools must permit also parents and guardians to file formal complaints on behalf of students. Now we talk a little bit about the definition of sexual harassment. There has been a huge change in what we had under the old information in the Dear Colleague letters and what was repealed to comparatively the definition of sexual harassment under the new regulations, which states unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive that it is effectively denies a person's equal access to the school's education program or activity. In the previous language, they talked about in the definition that the language said any unwelcome conduct of a sexual nature. Again, you can see that there is some very large changing in regards to the language here, specifically where it says that it must be determined to be so severe, pervasive, and objectively offensive. And this is critical when we're looking at how we have to implement and what we're looking at with our policies and procedures, the new Title IX regulations and where we have jurisdiction. The regulations also make it really clear that Title IX prohibits physical sexual misconduct, such as sexual assault, dating violence, domestic violence, and stalking, as those terms are defined under other federal laws called the Clery Act and the Violence Against Women Act. And the final piece to it under the sexual harassment and the three prongs is the quid pro quo definition. And this basically states that in these new regulations, school employees conditioning an educational benefit or service on an individual's participation in unwelcome sexual conduct. People often refer to this obviously as the quid pro quo harassment, which is offering a benefit in exchange for unwelcome sexual conduct. Moving on, we're going to talk a little bit under the new regulations of what is our new jurisdiction. I know that in prior years and we received Dear Colleague letters, there has been a lot of communications back and forth in regards to what jurisdiction looks like. Under the new regulations, they have come out and made it clear and saying that the new regulations must, under the new regulations, we make clear that the universities must respond to any sexual harassment that takes place in the school's education program or activity. This includes not only incidents that occur on school grounds, but also incidents that occur in context where the university has substantial control. This would be including buildings owned or controlled by recognized student organizations. And this specifically has to do when you're talking about the application, for instance, with fraternity and sorority houses, whether on campus or off campus, if the fraternity or sorority is officially recognized by the school and that the fraternity or the sorority owns or controls their building, it would have jurisdiction. So they've made some clarification on that. Part of looking at jurisdiction and when cases can be dismissed, they've also put in two particular ways of looking at it under mandatory dismissals and discretionary dismissals. So when we're looking at mandatory dismissals, a school must dismiss a complaint that does not describe conduct that meets the definition of sexual harassment. So right here, as I gave you the definition of sexual harassment, specifically looking back to determine if it is so severe, pervasive, and objectively offensive, right, that it effectively denies a person's equal access to the school's education program or activity. And then we have the other ones that are defined by the Clery Act and VAWA, and then quid pro quo. So if it does not meet one of those components of the sexual harassment, we don't have jurisdiction, and the school must dismiss based on that piece. A school must also can dismiss in regards to it if the sexual harassment that occurred, that the allegations of sexual harassment that did not occur in the school's educational program or activity, or that it did not occur in the United States at all. So the new regulations has made it clear, and again, when it looks at jurisdiction, where Title IX does not have jurisdiction on specific things like, for example, a study abroad and things that happen over there. That is not to say that there isn't other areas that wouldn't be addressing or that we still would not be providing individuals with resources. It's just saying we might not have jurisdiction to do a Title IX investigation. You have discretionary dismissals. Now, these are where the circumstances when a school is allowed to use its discretion to dismiss a formal complaint or some of the allegations in it. A school can choose to dismiss if the complainant notifies the Title IX coordinator in writing, meaning that the complainant wishes to withdraw the complaint or some of the allegations. This is discretionary and can be done, but it has to be done in writing, and it has to go to the Title IX coordinator once a formal investigation has been commenced. A school can also choose to dismiss if the respondent is no longer enrolled or employed by the school, or if specific circumstances prevent the school from gathering evidence sufficient to reach a determination about the allegations. In each of these situations, the school can dismiss a formal complaint, but it also has the option to proceed if it doesn't think dismissal is appropriate. And there are very few cases, but there are circumstances where this may apply. But those are situations in which we have to look at and see for the greater good of the community. Educational program and activity. The final regulations do not prevent a school from addressing misconduct that violates a state law or violates the school-owned code of conduct, even if the misconduct is not sexual harassment under Title IX. So again, the piece here that's really important is that it may not fall under a Title IX violation based on what the new regulations say. And when we are working on our policies and our procedures, this is a critical point where we are collaborating with our partners, with the Office of Human Resources, the Office of Student Conduct and Community Standards, and the Faculty Labor Relations Office to make sure that if it is not something that does not fall under the Title IX regulations, it doesn't mean that anything that has been brought to our attention is automatically dismissed. It may be going to a different area where there is a different policy that would have jurisdiction even under Title VII. So again, Title IX versus Code of Conduct, HR, Faculty Labor Relations, and jurisdiction is something that under these new regulations, we have to make sure that as we're reviewing everything and putting all of our policies in place and our procedures in place, that we make this division clear and have people understand how this process may go. Another piece is, as I shared earlier, that under the new Title IX regulations, it is only applicable in the United States. It does not include those studying abroad, but let me again reiterate that if something were to happen, whether it be with a faculty or a staff or a student on a trip abroad, there still might be other areas where in other codes or other policies that dictate, it just wouldn't be Title IX. But Title IX would be there to offer resources, supportive measures, and academic or workplace adjustments possibly, as this is something that we would be involved in if it is reported to our office. Reporting of complaint to the Title IX coordinator. We have to ensure that the Title IX coordinator information is basically everywhere, all over our institution, on the websites, on applications, whether it's for undergraduate, graduate, whether it's for anywhere that you would be applying to be a part of the University of Toledo community. There has to be information that specifically gives all of the Title IX contact, who that person is, along with their contact information. This is also going to be important to be seen on labor agreements and all of the marketing and communication as we are working through this process. So the school's mandatory response obligation under the new Title IX regulations. This basically says we offer, this is mandatory once we receive something in, that we offer resources and supportive measures and academic or workplace adjustment. We also have to explain to individuals that they have a right to file a complaint and how they can file a complaint, right? We also need to discuss that there is a portion of this, if it is a formal complaint, that they have to agree to the cross-examination piece of the process to move forward with that. And they have to be okay with understanding that the cross-examination piece is part of the Title IX formal investigation process. From the start of a proceeding, universities must now provide students with detailed notice about the allegations against them. The regulations require universities to disclose, prior to any interview, the identities of the parties involved in the incident. If known, the conduct under the regulation that might be considered what the violation is, and the date and location of the alleged incident, again, if known. It allows for both parties to inspect and review any evidence obtained as part of the investigation, and is directly related to the allegations raised in the formal complaint. As I'm sharing some of this information with you, I want to share that these regulations, I am again giving you just broad-based overview. There is still a lot of information as you drill down through the process that will be part of our policy and procedures based on what is determined under the regulations that we have to implement. The stuff that we are sharing with you today is just some of the high level, bigger pieces that we know that people have, asked us about under the new regulations and what our obligations are. So again, I want to make sure that everyone understands that this is just a short snippet today where we're sharing and doing a listening session so that individuals can share with us some of their concerns or ask questions. Moving forward, we're going to go through the grievance process. And this is a really big new piece to the regulations where they talk about advisors. The regulations also make it clear that cross-examination can only be done through an advisor rather than the parties themselves. So each party has a right to an advisor of their choice to perform cross-examination during the live hearing. If a party does not have an advisor, the university will provide one for them. Free of charge, and the advisor. Now the regulations, again, I want to make very, very clear, never state that the advisor needs to be an attorney. When somebody's choosing who they want as their advisor, if they're choosing somebody to come with them, that is their choice. If they don't have anyone, and during the process and only during that piece of the process, the university is responsible for making sure that there is an advisor to ask those questions during the hearing process. Hearings. So higher education institution must hold a hearing to adjudicate any report of sexual harassment. So again, if we go through the formal investigative process, that we are mandated now that they must hold a hearing to adjudicate any report of sexual harassment. Some of the requirements of the hearing, and this is just a couple of the highlighted ones because there are quite a bit more. A mandatory presumption of innocence of students accused of sexual harassment, which applies until the conclusion of the grievance process. Hearings must be live, whether in person or remote or technological means. Each party will have the opportunity to select an advisor of his or her choice, which can be an attorney, as I've shared before, or not. If the student does not select his or her own advisor, the school will provide one for free. And again, it is not stating in the regulations that this is somebody who has to be an attorney. Each party involved and each witness will be the subject to live, real-time cross-examination by the party's advisor. So again, to reiterate, these are going to be live hearings. The regulations recognize hearings can be virtual, that the cross-examination provided to the party's advisors by the party's advisor to the complainant and the respondent. In the hearings, there's also language in regards to the rights to appeal and, of course, retaliation language. One of the other pieces that they have talked about is the new part with informal resolution process. This is something that schools and universities may have the opportunity to offer this. It is not something that is mandated. It is up to the universities if they would like to be able to offer that and if it's applicable. But one component of the informal resolution process is that the schools must not use an informal resolution process such as mediation to resolve allegations that a school employee sexually harassed a student. In those cases, the informal resolution process would not be applicable. And finally, last thing I'll be talking about before we go into the listening session and we give people opportunity to talk a little bit about some of the information that we have shared or any of the research maybe that they're out there doing is training of people involved in the Title IX process. The regulations require not only the universities train Title IX investigators and adjudicators during this process, but also using materials that do not rely on sex stereotypes and that promote impartial investigations and adjudications, but also that the university must make the training materials publicly available on its website. So again, on the training piece of it, all training needs to be posted online. All persons involved in the Title IX process need to be trained. So go to the next slide. As we talk a little bit about this, I want to make sure that everyone knows, and before we go into the listening session, that we have community resources. The University of Toledo Counseling Center, this is for students only, you'll see the number. The University of Toledo Center for Student Advocacy and Wellness, number is 419-530-3431, and this is for students, faculty, staff, and community members. The YWCA Rape Crisis Service, 1-866-557-7273, and this is for students, faculty, staff, community members. And then we also have resources with the Employee Assistance Program Impact Solutions, which is 1-800-227-6007. This is for the University of Toledo employees only. And I want to go back. The University of Toledo Counseling Center for students, again, which is a confidential resource, is 419-530-2426. Thank you. All right, so now we're going to go into the question and answer component of this listening session. If you have any questions, please be so kind to post your questions in the question and answer Zoom feature. Your questions will be reviewed by the UToledo representative and asked by the facilitator, Lindsay Tuttle, who is on this WebEx, to our Zoom meeting to moderate with me. Again, due to the time constraints, we do know that this is only an hour long and that we may not be able to respond to all the questions. I just wanted to also share that we do have representatives from the different areas that I shared would be on this Zoom meeting. And if they are able to, and if there's a question, I will also defer to the panelists at this time.
Vicki, this is Katrina Notke. I'm going to be facilitating for Lindsay this afternoon for your question and answer session. It was a great overview of the regulations and all of the changes, right, that are forthcoming and will become in effect, right, on August 14th of this year. I do have one question that has come in that I would like to ask. How does a change to the sexual harassment definition affect faculty, staff, and students?
Well, thank you very much, Katrina, for asking that question. Earlier, I gave the definition in regards to what sexual harassment is under the new components of it. And where I'm going to tell you under Title IX, I kind of shared what our jurisdiction was, but I'm going to call on first Stacy Latta to talk a little bit about how that it might affect her area. If it is not a Title IX, if it does not fall under the definition in which would activate a Title IX investigation.
Hello, I'm Stacy Latta from Faculty Relations. So in the event that a faculty member is identified as a respondent to a Title IX or any complaint that's received that is fielded by the Title IX office, and it does not meet a definition within the Title IX policy, which would be the new definition for sexual harassment under the new regulations, then our office still has the ability to address conduct if it is inappropriate or negatively impacts the university community or members within the community through various other policies. The main one that would be used is called the Standards of Conduct Policy. And even if someone's conduct does not violate a policy, our office still has the authority to address concerning or problematic behavior on the part of a faculty, even if it does not meet the new definitions within the Title IX regulations.
Thank you so much. I'm now going to let Alex Lewin also weigh in regards to the Office of Student Conduct and Community Standards and where it might have implications there.
Thanks. So similarly to what Stacy stated, if the definitions or the behavior doesn't meet the definition under the Title IX regulations, the Office of Student Conduct and Community Standards may still be able to address the behavior. We will still have sexual misconduct policies in the Student Code of Conduct. And if something meets those policies, we may be investigating and adjudicating a case through the Office of Student Conduct and not through the Title IX office. Similarly, also to what Stacy said, there are sometimes cases that do not meet the threshold to be worthy of conduct charges, but where there still may be concerning behavior. And in those cases, we will make sure to speak with the students involved and educate them on what are the best ways to handle these situations and connect them to the necessary resources as well.
Thank you so very much. And I'm going to introduce Tiffany Murray from the Office of Human Resources to also share a little bit on her side of the part of the new regulations and the language that's in it and how it affects the policies that might come out of Human Resources.
So following a very similar vein of procedures, if a case arises that does not meet the threshold requirements under the new Title IX regulations that will go into effect, that case will then move itself over into our office, where it will be investigated under the non-discrimination policy and procedures. Concurrently with that policy, if there are any bargaining agreement procedures or policies that we have to adhere to, we would continue along that same path and adhere to those progressive disciplinary requirements. So again, the policy would require us to take hold of the complaint and move forward and follow it to its natural end.
Thank you very much. Another piece that I would like to share is that as we are working through our policies and procedures right now, we have not settled on what that's going to look like because we wanted to make sure that we met with all of our constituents and our partners across campus. And once the Title IX regulations came into, or that they released them on May 6th, we have had a timeline and been working through meeting with partners throughout the University of Toledo community and making sure that we have individuals the opportunity to weigh in through this process and understand what the new regulations are and possibly implications with the regulations. So this has been an ongoing collaborative effort through the whole institution to make sure that we do and look at everything and have for the best interest and safety of our University of Toledo campus community. Thank you.
Thank you, panelists. That was a great job answering that question. Very thorough answers. So I'm going to move on to the next question, Vicki. If I am on study abroad and a sexual assault happens, what are my options?
I'm going to share a little bit, and then I know I'm going to pass over some time to Alex Lewin to also discuss a little bit about this. As I shared with the new regulations, if it happens in a different country outside of the United States, Title IX does not have jurisdiction. But what Title IX does have is the ability to make sure individuals get all the resources and anything that they need to have that is available to them, and we will help through that process. Just because we don't have jurisdiction because it's not in the United States and under Title IX, other areas, all just like with all of our partners that have been speaking, they have jurisdiction maybe under different policies that would take somebody through a process. And I'll let Alex talk a little bit more about that.
Thanks, Vicki. So as always, the student conduct will remain in a way where it will apply both on and off campus to the student regardless of where they are. So any sexual misconduct that may fall under the student code of conduct, even if it doesn't meet the jurisdiction for Title IX, could be addressed through the Office of Student Conduct and Community Standards. Again, the respondent in that situation or the person alleged to have committed the behavior would have to be our student for us to take any kind of conduct action with them. Additionally, CIS, the Center for International Student Programs, will remain available to all students who are studying abroad. So if you need assistance managing a situation with the institution that you're at abroad, understanding policies there, understanding laws there, they will remain a resource for you as well.
Thank you. And as part of some of the meetings that we even have leading up to this listening session, we had the opportunity to sit down with the staff of CIS and hear really what their concerns were and for their students that might be going abroad. And we are collectively been working, myself and my investigator, Michelle McDivitt, had the meeting with them and are working through a checklist of things that we can do to also be very proactive. And some of the important thing about talking about the new regulations is what we have to do, but some of the really good work that we are doing and have been doing has been in the area of proactive work and making sure that if we put things into place and make sure it's fair and equitable, but we give individuals a lot of knowledge that hopefully that there won't be as much that we need to react to, that people will have the tools and the ability to move through all of this information.
Thank you, Vicki and panelists, for answering that question. That was a really good question. So our next question is a clarifying question. So will reporters still report any issues of concern to the Title IX office, and the office will make a determination about whether the issue meets the Title IX threshold? Then if not, Title IX will refer it to other appropriate office if needed.
Thank you, Katrina. Yes, right now, as we are reviewing and looking at our policy and all the information that we have and all the trainings that we've done, we are still looking at having mandated reporters and having people report things into our office. Again, it is really crucial for us to have that information to be able to affect change and make sure that we are taking the appropriate actions. Just because something isn't Title IX or falls under Title IX regulations doesn't mean that it isn't something that would be still handled in a different area. So we are still having it as if somebody learns of something, we are mandating them to make sure to report that information.
And if I can add, Vicki, our online reporting system, so that report a concern button at the bottom of all of our web pages is going to remain the same. So if you are not reporting directly to a person, but you're using that reporting form, we just expect that people will use whatever they feel is the most accurate form, and we will make sure, again, that it is routed to the correct places. So if it goes to Title IX and they feel like that it doesn't meet the threshold, then they will make sure that the correct office, whether it's Office of Student Conduct, or faculty labor relations, HR, for example, that they receive the report as well. So we understand sometimes people are not quite sure which reporting form to put in, and we do make sure that those end up in the right place. So as long as you report it somehow, we will make sure that it is addressed appropriately.
Thank you.
Thank you, Vicki and Alex, for answering that clarifying question. So I'm going to move on to the next question. If I am a student and I attend an off-campus party and I am experienced sexual assault or dating violence by another student, how do the new Title IX regulations affect me? And can I have a Title IX investigation?
Thank you so very much. And again, this is going to be something I'll partner with Alex on, because what's happened here is they've made it very clear kind of why I went through the definitions of where we have jurisdiction, what the scope of control for the institution is. So under what the question is as you've presented it, basically we would not have under Title IX jurisdiction any longer for that. But that does not mean that there wouldn't be anyone that doesn't have jurisdiction if there's some kind of conduct that's been reported off campus between two students. And I'll let Alex talk a little bit about that.
Sure, and similarly in this situation, if we doesn't meet the threshold like that we discussed earlier with the definition of sexual harassment, for example, if it doesn't meet the jurisdiction because of the location where it occurred, that is something that may then, instead of going through a Title IX investigation and Title IX process, would come over to the Office of Student Conduct and Community Standards, and we would do an appropriate investigation and then go through the Code of Conduct and process it in that way. I don't know if Alex Cernical wants to speak at all in regards to who may be hosting the event or the party off campus. If he's available to speak about that, he could share.
So when it comes to, if we're talking specifically about, fraternities and sororities, we at this point only operate university-owned the 14 houses currently on campus. So we know that there are organizations in our community that have what they consider their annex or their satellite houses where parties may be happening. Under the new regulations and conversations that I've had with Vicki and Alex Lewin, those do not fall under the jurisdiction of Title IX, but those situations could still be picked up and will be picked up by Alex Lewin in the Office of Student Conduct and Community Standards. So I hope that kind of gives at least some guidance in terms of with our fraternities and sororities moving forward.
Thank you so much, Alex and Alex. We know that that has been a big topic of conversation, this whole jurisdiction of when it is something that Title IX would have jurisdiction over and when we wouldn't. So as we're reviewing all of our policies and procedures, please know that we are also getting information from the top advisors around the country in regards to making sure that as we review and do what is best for the University of Toledo, that we are also looking at best standards and across the board and making sure that we are utilizing our experts also in the field. Thank you.
Thank you, Vicki and panelists. I just want to remind everyone on the Zoom meeting this afternoon, if you have additional questions, please feel free to submit your question. So I'm going to move on to the next question. What if I do not want to be cross-examined by a lawyer?
Under the new regulations, anybody can have who they want as their advisor. We cannot dictate whether a complainant or respondent chooses to have an attorney as the individual, as their advisor asking the questions. So, and it is as of their choice is the language that is in the regulations. So we don't dictate and we can't say for somebody not to, you know, be that person. Or if somebody does not want to be a part of cross-examination, this is a conversation, obviously, at the very beginning of the investigative process before a formal investigation is done, is that all these conversations and making sure people truly understand what the process under the new regulations is, so they can make an informed decision about what they want to do moving forward in these cases. We're very cognizant as a community and the individuals that are on this panel of making sure that this is a fair, equitable process for everybody that is involved through it. And these new regulations are something, and what we're talking about is not something that we as the University of Toledo are saying we're just going to do. These are new regulations that are something that we have to implement and make sure that we are compliant with.
Thank you, Vicki. I have my next question. What does an advisor mean, or what do they do?
I can talk a little bit about this, but I'll also let anyone else who would like to weigh in on this. And again, I think Alex Lewin might be also a good individual to share, or, you know, some of her experiences with what we are currently already doing compared to this. So an advisor, based under the regulations as we understand them at this point, is that they are only asking the questions. So for example, they get a list of questions that they are going to be asking the respondent. The complainant will be putting forth to ask to the respondent, and then that will be how that communication is going to go back and forth. So it's not direct question asking by the complainant to the respondent, that everything must go through that advisor role. So under, and again, reviewing our policies, an advisor may look very different than it has in the past in some of the language that we've used as a campus, because people could be involved in the process as an advisor in the past and not have that role. But now this name is specifically dedicated to doing this portion of the policies and procedures. And Alex, I didn't know if you'd like to add anything to that.
Sure. So we have had advisors and support persons through the conduct process for a while now, and it looks slightly different than what it will with the Title IX process. So advisors in the student conduct process will remain in their role the way it has been. So typically, those people do not have the opportunity to speak in a hearing. Those people are there to kind of quietly advise and support the complainant or the respondent, whichever party that they're with. They're also able to come to any of the other meetings that the complainant or the respondent has, and our hope is that they will help the parties involved prepare as well for their hearings, make sure they have all the information that they need, things like that. So if there's a case of sexual misconduct that is going through the student conduct process rather than going through the Title IX process, the advisor may be a little different. They could still be an attorney if that's what the person chooses, but they will not be participating in the same manner of asking questions through the student conduct process and the student conduct hearing.
Thank you. Stacy, did you want to speak a little bit about the current process and who's involved in those?
Well, it depends. So, and when a faculty member is a respondent, the complainants can be a faculty member, a staff member, a community member, a student. So on the faculty side, if the faculty is a member of the AAUP collective bargaining unit, then they're entitled to have an AAUP representative. So this could be another faculty member who serves as a representative as part of their membership with the union, or it could be an attorney that the AAUP has hired to represent a faculty member who is being subject to potential discipline. So typically when there's a investigation, a complaint, there's potential for discipline. So in those situations, the faculty member would be represented by either an AAUP representative who would be not an attorney, an AAUP attorney. They could represent themselves if they don't want to use a representative, or they could bring their own advocate if they would like So with regard to the person who has filed the complaint, the complainant, that individual would be able to bring an advocate. It could be an attorney. If they're a student, they could use the same student advocacy process that Alex described in when a faculty is a respondent. If they're a non-union faculty member, they also have access, I believe, to have an advocate, or if they want an attorney, they're also able to do that. So really we provide a lot of flexibility with regard to who they can, if they want to have some sort of support person or advocate present in the process. Now we might limit their involvement. So for example, if someone's just a support person, we're not going to allow them to participate in asking questions unless they've been identified as an advocate. And all of that is clarified prior to the hearing, or any opportunity where some sort of cross-examination would go on.
Thank you. I know we've got 17 minutes left as I watch. Tiffany, would you like to share anything in regards to the human resources process as it currently is compared to now looking at having this advisor role only in Title IX cases?
Right, very quickly, it's a very similar looking model to what Stacy just mentioned a moment ago. If there is a represented employee, they can bring in their union representative with them, or they can bring in a non-union person as their advocate in that meeting, or a friend. It is their choice, but they can bring an individual to those meetings, even at the earliest stages, even at interviews, so that they can feel as though that there's another individual who is able to witness the proceedings. Similar to what Stacy described, there are some limits to the level of involvement and interaction that person may have, and that's consistent with our current policy. So a very similar model. It will look a little different in the once the new regulations move forward, though.
Thank you so very much.
Thank you, Vicki and panelists, for answering that question. It was great. So I'm going to move on to our next question. Will there be any comparison done in the next couple of years to determine whether the mandated regulatory changes had a chilling effect on students' willingness to report issues?
Again, in regards to the new regulations and everything that has now been put into place and that we have to implement, by August 14th, I think that as we move forward, what we already do is we do surveys every year, and we put out information. And I'm going to let Lindsay talk a little bit about what we currently do in regards to making sure that we know and our obligations. And this may be an area in which we can gather some of this information. Thank you, Lindsay.
Yeah, so I think this is a really good opportunity that we could benchmark this question. We do climate surveys yearly. They are done typically in the spring, the climate surveys, and are distributed to faculty, staff, and students. We also have a mandated report for the Ohio Department of Higher Education, where we are asked very similar questions. So I would not be surprised if ODHE implements some type of benchmark question related to that as well. In our current format, we also do trainings, bringing in the bystander, as well as Title IX trainings, where we have pre and post test evaluations, where we might be able to utilize some of that questioning there. And then also in our programming, our major large programming, we do evaluations and assessment as well, that we might be able to utilize some of that questioning.
Thank you so very much.
Thank you, Lindsay and Vicki, for answering that question. So I'm going to move on to our next question. Again, if anyone else has questions they would like to submit, please use the Q&A feature, we'd be happy to review your question, considering answering that question for you. So a respondent can have an emotional support person and an advisor. Does this also apply to complainants?
Yes. Yes, and Katrina, if you would like, you're more than welcome to answer that question in regards to our investigative process and our current policy, what it says on that, and then moving forward.
Sure. So with our current policy, and this will move into the updated policy as well. Again, we will be updating the policy just in time for those new regulations to go in effect on August 14th. And so right now, both complainants and respondents and in the future, they will have equal rights. Okay, so both are have the ability to have a support person and an advisor with them for their meeting with the investigator to discuss the allegations and to understand what happened. And then also that support person and advisor can follow that the respondent or the complainant through the process, if you will, and even attend the hearing with the complainant or the respondent as the investigation moves out of the investigative mode into the adjudication mode, if you will. And it will go either to the student conduct office, to human resources, or faculty labor relations, depending on who the responding party is, whether or not they're a student, faculty, or staff. But yes, that would be equal rights for both parties. Both can have an emotional support or a support person, as well as an advisor to attend with them as well.
Thank you so very much. And again, as we talk about advisor, we want to make sure to understand that under the new regulations, that what an advisor's role in the actual hearing process is going to be very specific to that. So does anyone else want to share anything on that one? Okay.
That looks like that is the end of our questions, Vicki. If you would like to maybe add some closing comments, that would be wonderful. As you are adding some closing comments, if we have any additional questions come in, I'd be happy to take those questions. We have about 10 minutes left. Thank you.
Thank you again. Lindsay, if you can advance the slide. First off, I wanted to make sure everyone knew again that the University of Toledo obviously has a Title IX office and the office contact information. If you have any questions or you want to review more information or materials or have any, want to put through anything or file a complaint, the website information is up there, which is www.utoledo.edu/title/IX/. But also the phone number to the office is 419-530-4191, and we are open and we are taking information. We are still remotely working, but we have been up and working this whole time. I wanted to make sure everyone know that if they have any concerns or they would like to speak to someone, you can reach that number. And then the email at title9ix@utoledo.edu. So as we move forward and as we've been progressing through the new regulations, first off, I would like to thank everybody on this panel and individuals who have taken their time to participate today and be a part of this, but also come to the listening session. It was really important when the new regulations came that we gave individuals an opportunity to have a space where they could hear a little bit about some of the work that we've been doing. Knowing that these are still in the policy development and procedure development phase, and that we wanted individuals to have an opportunity and a space at the table to, let us know what their thoughts were. A lot of the things that are going to be taking place and the changes to our policies and procedures are regulated under the new regulations, but we are still taking, in information and into consideration information. So if, again, you want to share anything or if you want to reach out to me personally, Again, my name is Vicki Kalicki. I'm the Director of Title IX and Compliance, and I'm also the Title IX Coordinator for the University of Toledo. My email is Vicki, V-I-C-K-Y, .Kalicki, K-U-L-I-C-K-E, @utoledo.edu. And you can reach me at 419-530-4191, which is the main office number, but it is one that is always being monitored and I have access to me. In closing, I am grateful for everybody that was here today and took their time to listen to our virtual listening session. And again, I want to thank the leadership at the University of Toledo, specifically Dr. Cockrell, who's been extremely supportive and has made sure that the Title IX office is really just doing wonderful things under his leadership. So I really want to thank him for always supporting all the work that we're doing with Title IX at the University of Toledo. Thank you.
Thank you, Vicki. We do not have any additional questions that have come in. So if there aren't any additional remarks, this will conclude our session this afternoon.
This will be the last of the panelists. Is there, if anyone would like to say a closing remark, you're more than welcome to at this time. Okay, I made a big mistake and I probably should have gone through really quickly of my panelists and let them introduce themselves just real quick about who they are and what area they're in. They have been wonderful partners. I will tell you, because this is only 1 hour long, we have amazing partners all across the campus who have been engaged in this process, who I shared earlier we've been meeting with. We just couldn't have everybody on this. So I just want to really quickly let individuals, and I'll unmute you as we go. So Alex Zernickel, if you'd like to go. Oh, I can't unmute you. Oh, there you go.
Okay. My name is Alex Zernickel. I serve as the Assistant Director for Greek Life in the Division of Student Affairs.
Thank you.
Hi, I'm Lindsay Tuttle. I'm the Sexual Misconduct Prevention Education Coordinator.
Thank you. I'm trying to unmute you. I'm sorry. Go ahead.
That's okay. Good afternoon, everyone. I'm Katrina Notke. I am the Assistant Director for Title IX and Compliance.
Stacy, I'm trying to. Stacy Latta, I'm sorry.
Here we go. Hello, I'm Stacy Latta, and I am the Associate Director for Faculty Labor Relations.
All right. Alex?
Hi, I'm Alex Lewin. My pronouns are she, her, hers, and I'm the Interim Director of Student Conduct and Community Standards.
Michelle? Nope, can't hear you. You're on mute. Oop.
Got it. I'm Michelle McDevitt. I am the Title IX investigator in Title IX.
Thank you. Tiffany?
Hi, everyone. Tiffany Murray. I'm the Director of Equal Opportunity and HR Compliance.
Thank you so much. And then Dr. Cockrell?
Good afternoon, everyone. My name is Flap Cockrell. My pronouns are he, him, and his, and I serve as the Vice President for Student Affairs and Vice Provost. And I would like to say a special thank you to Vicki and her team and all of our panelists for participating today. Title IX is something that I hold very near and dear to my heart because we believe in protecting our entire university community. So I would like to thank you all so much for your hard work and your dedication to ensuring that our campus is safe. And also thanks to all of the panelists who tuned in to learn a little bit more about our upcoming Title IX regulations. Thank you so much. Take care and be safe.
Thank you so much. All right. Have a wonderful night.